Am I audible?
Yes, sir.
Okay.
Yes, sir.
We'll start in 2 minutes.
Yes. Good evening, everybody.
Good
Hello.
evening, sir.
Good
evening, sir.
Good evening, sir.
Thank you. My name is N.R. Naik. My office name is N.R. Naik Associates. Today, important subject, Section 6 and Section 14 of Hindu Succession Act. How the female of a member of family, joint family, Hindu joint family, how she is going to get the property in question. The properties which are joint family properties as well as the co-partnership properties called as the property which is enjoyed, inherited from ancestors as well as the common stock was available with the family. Those who are entitled equal share along with the son. One case from our own Honorable High Court of Karnataka, Prakash versus Pulavati case. That is in those days, Lordship Justice Kumar. What the judgment delivered, those who are born after 1956, they are eligible for partition. Likewise, such judgments throughout India, more than 100 judgments are referred to Honorable Supreme Court. Then clarify the matter in Vinod Sharma versus Rakesh Sharma. Please note down, this is the final judgment delivered. Discussion has been made. All the ingredients, how to be proved, how the property is devolved to the female member of the family. Vinit Sharma versus Rakesh Sharma, reported in AIR. AIR, Supreme Court, 1920, page number 3717. So this fact has been brought before the Honorable Supreme Court for clarification, because several judgments are one or the other reason they are following the Prakash versus Pulivati case, and some difference opinions are started among the various high courts. Therefore, the matter has been brought in Vinod Sharma's case and decided the points like this. So, first of all, you have to learn what is the section 6 says. Section 6 says, just to note down point of law, devolution of interest in co-personary property on the from the commencement of Hindu Succession Act 2005 in the joint family governed by Mitakshara law, the daughter of co-partner shall how she wants to get, because 2005 the act came into force. That is the act, amended act 2004. Female member, how she is going to get the property belongs to ancestors or joint family property, how she is entitled and what type of right she is having. So therefore, when that matter came into force before the Honorable Court, now prior to Vinod Sharma's case, there is no any property, because in Kannada word saying that Kothennu Kulakke Horakke, once she is married, she won't get any right from the ancestral or co-personary property. Therefore, that point was discussed in Pulvati versus Prakash case, that was decided. Therefore, she is also entitled, because what happened in that case, because our own Honorable High Court was decided stating that when male member is also marrying, why you are saying ಕೊಟ್ಟೆಣ್ಣು ಕುಲಕೋರಕ್ಕೆ ಆತನಿಗೆ ಯಾಕೆ ಹೊರಗೆ ಹಾಕೋದಿಲ್ಲ ಅನ್ನೋ ಲೆಕ್ಕದಲ್ಲಿ, that is the point involved in that case, and decided section 5 upheld, and she is also entitled by way of birth itself she is entitled to claim partition in respect of joint family property. When son himself is enjoying co-personary property, why can't the female member is also enjoy along with him equally? That is the word has been used. Equally, she is also entitled along with male member. That is the law. Law has been laid down in the said section in the year 2005 by way of amendment. So therefore, the first female member, how she is entitled by birth become a co-partner in her own right in the same manner as the son. The word has been used by legislature. When son is having right, the same right shall be devolved to the female member also. That is the section 6A. Part A says that whatever son is getting, the same thing female is also having right to claim equal share along with him. Now B what it says, have the same right in the co-personary property as she would have had she had been as son. Whatever the property she is also having, if co-personary property is having, the son is also entitled equal share along with female member. And C, This is liabilities. Any liabilities of the, now, when daughter claiming equal right, the liability is also fixed on her. Whatever liability of Hindu family, the same thing is going to be discharged by female also. When she is getting equal share, she is also entitled to discharge her liabilities of the Hindu family or co-personary family or Hindu joint family. So this is the law laid down under section 6A. Now, what is the restriction has been made in this law? The restriction is this. When the act came into force on 9/9/2005, which was effected by the legislature, this date is noted down. Female is entitled equal share with effect from 9/9/2005, because that act came into force, and she is entitled equal share along with male person from 9/9/2005. Therefore, when she is entitled equal share, these are the condition has been laid down. Now, what is the explanation into these effect? When she is entitled equal share along with son, what is the effect on that? Now, one condition has been put. This condition is provided. Kindly maybe look into in this section 6. There is a proviso. What proviso? What condition that laid down in the proviso? That nothing contained in the subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition of property which had taken place before 2012-2004. This is the condition has been put. So therefore, what is the word they have used? When the act has been introduced on 9/9/2005, this is the proviso has been put in that, stating that disposition shall affect, invalidate any disposition or alienation or including any partition or testamentary disposition. See, one thing,
Sir,
disposition.
one sec. There is a lot of noise from other people. It's breaking off, sir. Can you please ask people?
Please call them because they are the friends. So what can I do now? They are also coming, joining for this. Let it be. Now, you see, this is the proviso has been made. First, invalidate any disposition means 2012-2004. Before that, any disposition was took place, any joint family property disposition was took place, it cannot be thrown into common stock for partition, or she cannot claim, or anybody cannot claim once it was dispossessed by the father, by the brother, father himself, partition among the children, it should be registered partition. That is the condition has been put in that. Including any partition, alienation, including any partition. Alienation means sale deed has been executed by the father and sons. They have alienated the property prior to 2012-2004. This is the restriction. Women to claim for partition if the property is not dispossession or sold or partition among the joint family members before 2012-2004. Now, another word, or testamentary disposition of property. Testamentary disposition of property means will, gift, or any transfer. Any transfer took place prior to 2012-2004. This is the restriction available for women should not claim for partition. So therefore, when this section 6 is introduced, by way of amendment. Since then, since decided by the Honorable High Court of Karnataka Pulvati case in the year 2018-19, then thereafter several cases are decided. Then 2020, finally, before Honorable Supreme Court decided, by birth itself female, she is entitled if the partition was not took place, if alienation was not took place, or if any testamentary document is not executed. Likewise, these restriction was made, they are entitled. Now you may ask me, sir, anything, property is available, but enjoying by way of arrangement by the family members. Then whether it is possible to get a partition? Yes, definitely. Because it is arrangement only made among the family members because for expansion. Therefore, that arrangement is not going to deprive the right of female. Right of female. Therefore, the restriction has been made, any dispossession, any alienation, any partition, any will, any gift or testamentary document before executed as on 2012-2004, she is not entitled to claim. Question those documents prior to, that is the date was available with the family members. So this restriction has been made, amended provision has been introduced, that was effected from 9/9/2005. So therefore, the section 6 is very clear. This property, how to devolve, that shall be included in the so and so. Now next to one further step has been gone. Now I think you have noted Vinod Sharma's case. Now our own Honorable High Court of Karnataka decided at Dharwad bench, Honorable Justice Mugdam sir, that is in Channabasappa versus Srimati Parvatyawa. Please note down this writ petition number, which was disposed of by Honorable High Court of Dharwad bench, Channabasappa versus Srimati Parvatyawa. What happened? Parvatyawa died. When Parvatyawa died, the Channabasappa filed an appeal before Honorable High Court of Karnataka at Dharwad. Parvatyawa, if died, why should we provide the property in favor of her legal heirs and successor? In this case, what point of law is decided? Even though the female member died, because her birth was took place in that family. Her birth was took place in that family. Therefore, if died, even if die, definitely her legal heirs are entitled equally with her brother-in-laws. That is, because sister died, her children are legal heirs, they are entitled to file share against her brothers. So therefore, this case was decided based on
ఇన్ని రోజులు నేను ఏ రోజు నాకు ఇబ్బంది రాలేదు కానీ ప్రాపర్టీ ఇన్సిడెంట్ జరిగిన నుంచి పెయిన్ అయిన నుంచి, లేదంటే ఎవరన్నా మార్కెట్ లో ఎక్కడన్నా ఒక్క దొరికితే
ప్లీజ్ సార్,
అయిన వీళ్ళు రాలేదు.
ప్లీజ్ మ్యూట్ సార్,
రాత్రి పగలు ఆయన ప్రతాప్ గారు
ప్లీజ్ మ్యూట్ సార్.
పెద్ద పని కూడా లేదు.
హలో,
ఎవరన్నా అంటే చూడు బాబు, ఎందుకంటే సోమవారం నుంచి వీళ్ళు పెయింట్లు మొదలు పెడుతున్నారు. ఈ పూతలు కనీసం 2 రోజులన్నా ఆడితే రేపు ఆదివారం
సార్ తెలుగు టాకింగ్ సార్, తెలుగు టాకింగ్ పర్సన్, ప్లీజ్ మ్యూట్ సార్.
అపాలజీస్ సార్.
Thank you. Sorry. Right. Now what I am saying here, WP number, just you note down, writ petition number 105363/23. It was decided last year on 20th day of December 2023 at Dharwad Court bench. This was decided in case of Channabasappa versus Srimati Parvatama. Parvatama's legal heirs, she died, and they have questioned. Channabasappa questioned that decree passed by the trial court, since our sister died and only we are entitled, kindly maybe modify the decree passed for effecting the partition of immovable properties of the joint family. Therefore, that point of law has been brought. No, when Parvatava, though she was a party to the proceeding, but her claim is from the date of birth. Therefore, she is also entitled equally along with your brother, and hence her legal heirs are entitled equal share. That has been decided. Now several cases are filed by us also. Now, this problem brought before me. Several persons they have brought. Then what type of claim? Now you see 9/9/2005 is the deadline. They have to file a case after only 9/9/2005. Then corpus nari they shall be proved whether she is entitled for getting position or entitled for partition. All these things shall be decided by the court. Now also we are entitled to file a case, because when there is no partition, when there is no sale, when there is no will, when there is no any gift executed prior to 2012-2004. Therefore, 9/9/2005, that is the date has been given for the women. They are entitled equal share of partition. That is also that case has been decided. Now legal heir also entitled equal share of their mother, of their female member in the family. So this fact, we remember that this is the writ petition subsequent to Vinod Sharma's case. It was decided in the year 2003. Vinod Sharma's case was decided on 28/2020. So therefore, before Honorable Supreme Court, it was landmark judgment for the female is concerned entitlement of the. Later I will discuss for this, because the differences you should know how the female member become the absolute owner. Then only you can understand about this partition also. So therefore, section 6 is very clear. Two restrictions are made. One restriction is if the properties are alienated prior to 2012-2004, she is not entitled to file a case before the court for partition, and those documents cannot be questioned before the court. So this is the point of law has been decided in Vinod Sharma's case, and since then now we are filing the cases before the court. Before the court, and entitled equal share along with male members. So that is the law decided before the Honorable High Court of Honorable Supreme Court of India. Vinod Sharma versus Rakesh Sharma, reported in AIR 2020 Supreme Court, page number 3717. That is been decided. Since then, we being advocates, we must advise them to restriction. If it is removed, then only you are entitled, otherwise you can't. So that type of advice you should make. And several people are also approaching us. Now, you see, the amended act came into force only with effect from 9/9/2025. But in that case, when it was decided by birth itself, right is available. Therefore, I want to file a case because my father and my brothers were divided and affected. They themselves cultivating the land, but there is no document. Likewise, they are coming now. Every coming. And even female member dies, and one of the brother having the joint family property, he constructed industry, he is having business, everything. They are coming now. A very now burning problem in India now, because the partition female members, they are also getting equal share along with the male members. If any property co-personary property is available, movable and immovable property. Both property, she is entitled equal share along with son. That is the law decided in Venus Sharma's case, and also Chanbasappa Srimati Parvatama's case. It was decided, Parvatama case decided legal heirs of the deceased co-partner, they are also entitled. Now one thing, one question you may ask me, because once she died, how she can question about the partition? Then they are also, children can file by making the necessary parties of her brothers, and they are also entitled equal share along with them. Even now also they can file, provided they shall not alienated before or prior, before 2012, 2004, 2004, not 2014, 2004. Kindly maybe look into the Vinod Sharma's case. Definitely you are going through anything. Now, what Vinod Sharma's case says. Vinod Sharma's case like this. There are 5 points decided in this case. Whether male members are entitled equal share along with their brothers during pendency of the suit or anything, all the more than in this case, more than 101 case decided by Honorable Supreme Court, and all these matters are referred and all the cases are overruled. So first question was decided in this case. Kindly maybe note down point 1. Point 1 decided daughter born before amendment can claim rights only from 9/9/2005. This act came into force in the year 1956. That is Act, Hindu Succession Act, 1956, that was introduced. That was introduced, but Section 6 was amended only with effect from 9/9/5. So therefore, it is this first point they have decided, daughters born before amendment can claim rights only from 9/9/2000, because amendment was 9/9/2005, and whatever the properties are available with their father and brothers, she is entitled only from 9/9/2005, not prior to that. So therefore, that restriction, why it has been put, she is entitled equal share, though the co-personary property is not partitioned. Therefore, she is entitled to claim property from 9/9/5. First point, this was decided in that case. Now the second point, this is the word the Lordship has given, verdict. Daughter would step into the co-personary as that of son by taking birth before or after the act. However, daughter born before can claim these rights only with effect from the date of amendment, that is 9/9/2005, with the saving of the past action, that is the proviso, so and so, all the proviso are available in this. So therefore, effect of the amendment is that daughter is made co-partner with effect from date of amendment, and she can claim partition also, which is necessary commitment on co-partnering. Section 6(1) recognize a joint Hindu family governed by Mitakshara law. The co-partnering must exist on 9/9/2005 to enable the daughter of a co-partner to enjoy the right and conformed on her, as the right is by birth, not by inheritance. it is irrelevant that a co-partner whose daughter is confirmed with the right of alive or not. So therefore, this point kindly maybe look into inheritance. Anta one word has come now in this judgment. Sir, inheritance automatically by birth she may claim right over the property. But inheritance means 1956, only the act came into force. Therefore, inheritance is not applicable. 1956 onwards, automatically by birth itself, even act came into force on 1/1/1956. She is born prior to that. She is not entitled. By birth it is meaning it is entirely changed. So therefore, that particular point also decided in this case, Vinod Sharma's case. Now the second point, what is the 99/2005? That is elaborately discussed. Second point has been decided, co-partner right. Daughter is made co-partner with effect date of amendment, and she can claim partition also, which is a necessary concomitant of the co-partnery. Because what is the word meaning in this case? She is also entitled, whatever the property which are properties are not affected the division, the same is also entitled. Third point, deemed partition. No disruption of co-partnery by statutory fiction of partition till actual partition was took place. No uncertainty is brought about the provision on 6. Now, what is these words says? Third point is concerned. Where partition bhaga agogide, already partition was took place. Yeah, the properties are not available. You need not claim. Therefore, the partition should be registered prior to 2012-2004. Then only she cannot claim. So therefore, that is also deemed partition also cannot claim. And next point, it was decided, even though preliminary decree has been passed, preliminary decree and final decree, what is the difference? Now, today I am going to file, I am entitled 1/6 share. 1/6 share determined by the court by passing the judgment. That is called as preliminary decree, only 1/6 share. Final decree, what it says, after deciding the preliminary decree, I am entitled 1/6 share. Therefore, my 1/6 share shall be effected division. That is also given in effected preliminary decree. Even though order has been passed, you are entitled equal share along with male members. Now, preliminary decree has been passed. Final decree is still pending. Definitely she can participate in the final decree proceeding, and she is also entitled equal share along with male member, even though she is not a party in the preliminary decree. Therefore, that is also decided in the fact. And next question is, the oral partition should be registered. Now, tomorrow, father and brothers, they may claim just 2012-2004. That is the restriction year. Therefore, you are not entitled. It cannot be. So, therefore, that restriction, they shall prove what are the documents were available to deny the partition, for which that is the restriction has been made. It shall be registered. Oral partition ruled out. Oral partition if took place between the brothers and father, because oral document is acceptable in the Transfer of Property Act. So when such being the case, such oral partition is not applicable in Vinod Sharma's case or in the joint family property, those who are going to claim. Therefore, that particular property is not available for if the oral partition was took place, it is ruled out. That can be questioned and that can be claimed for equal partition along with other family members. These are the points are decided. Vinod Sharma's case, more than 101 cases from all the high courts of India. They have referred the matter and it was decided finally in Vinod Sharma's case, this point, by birth itself she is entitled, and from 9/9/2005 she become a co-partner, and restriction has been made. Any dispossession, any alienation, any gift, any testamentary documents was took place. Those matter is not, those properties are not available for partition prior to 2012-2004, not 14/4. So this is under section 6. Now, another section, very, very, very important. Kindly maybe section 14, note down. How Hindu woman having right, Hindu woman, Hindu female member, how she should be declared as an absolute owner. This is the section 14. It was decided. Property of a female Hindu to be her absolute property. That is called as section 14. So what is meant by absolute property a female is having? Which are absolute property? Now, she is divided. She is one of the co-partner. Does not mean that she is going to inherit it to her children. Definitely, it is inherited. It is not absolute ownership property. When property, portion of property is allotted to her, if nobody is there, then again it is devolved to her brother. Therefore, absolute ownership, it is not available wherever the property has been given under partition. Now, next question. So, which are the properties? What are the properties to be claimed as absolute owner? That is the point. Explanation. How she is absolute owner, that is explanation has been given. In this subsection, property includes both movables and immovables. Immovable property acquired by female Hindu by inheritance. Kindly maybe look into. Now her father is available or her husband is available. Husband died, she has been inherited, no children are available. So that property she is absolute owner. She can dispossession. She can dispose of the property as absolute owner because she has got ownership. Ownership, you know, the jurisprudence, what are the right is required is first possession, second right to execute the document, third right to entitlement of ownership, entitlement of transfer of property. These are the points are required ownership. So therefore, female Hindu woman is having a ownership right under this act. Inheritance. Which are the inheritance? You know, from her husband or from her parents, those it comes in inheritance. Therefore, it is allotted to her. Now, for example, I am providing. Father has given at the time of marriage. Inheritance, you are also entitled. Therefore, I am providing property as per partition. You take this. It is inheritance only. It has come to her. So therefore, that inheritance property is also entitled to claim ownership. Now next, by way of partition, if partition allotted to her. Next, in lieu of maintenance, divorce case is going on before the court. In divorce case, the properties are allotted in favor of wife. The wife allotted that partition property, she can claim absolute ownership. Now, just now, section 6 I have stated she is entitled equal share along with son. So that property, if it comes, she can claim absolute ownership of the property. Then maintenance, arrears of maintenance. The property is unable to pay the maintenance charges. Therefore, property in lieu of maintenance, property is going to give to him. This is also available. Gift from anybody else, any person. If property has been gifted in favor of a woman, she is also entitled to ownership. Whether a relative or not, before, at, or after marriage, by her own skill exertion, purchase, prescription, in any other manner whatsoever, also the property held by her as Stridhana immediately before commencement of this act. So I think you understood female, how she become the owner. These are the ingredients available to her and it is entitled. And this, in this case, nothing in this section shall apply to any property acquired by way of gift or under will or any other instrument under decree, order of civil court, under award, where the terms of gift, will, other instrument or decree or order, award prescribed restricted estate. Now, whatever the property allotted by decree, whatever property given gift, you should remain to possession for yourself, for your life. Then such restriction has been made, automatically she is not, it cannot be keep the properties as if her own. So these are the testamentary documents. It has to be proved in before the court of law. Therefore, section 14 is very clear. Women are having right to acquire the property by way of partition, by way of sale, by whatever the property allotted in her name, it is entitled by her. So therefore, woman's female property, she is the absolute owner of the property. Her brother, her father cannot be divided. Whatever the Stridhana property, she should avail for their own, and she is become absolute owner of the property. These are the two sections today. It is sufficient. I think tomorrow, likewise now partition, so many cases I have filed. So first I have to prove Kopasnar. She is one of the family member, born with, along with other family members. Therefore, female member is entitled. Now, one question you may put to me, stating that there is no male member, how can she ask? No, against father also, she is eligible, she is entitled to claim for partition, how the property father is granted. If self-acquired property of the father, it cannot be taken into consideration for partition. So, these are the points for section. Now, peoples are coming every day. We are filing partition suit nowadays, because even though aged about 80 years, women, just to calculate if the brother's property is not partitioned, their children going to file case saying that my mother born with them, but no partition was took place, the proper partition was took place, but they have arranged only, therefore we are also entitled, they can also file. Only you have to ascertain 1956 when it was, and 995 she must be proved the Kopasnar, saying that I am enjoying the property along with my brother, going to their house and getting the profits arise out of the Kopasnari property. That if it is proved automatically, that is a joint family property. So these are the points available for you relating to right of a female member and right of a absolute ownership of female member. These are the two sections today. It is advocacy is concerned, practicing is concerned, very, very good sections, good cases. You have also right to file several partition cases wherever the deprivation has been made to the female member. This is the point today. It is sufficient for you. I think any question, kindly maybe call me. I will answer for that.
Sir, can we ask one question, sir?
Please, please.
Sir, under section 14, you said women will have absolute right, ownership of the property.
Yes.
But if she wants to sell her property, should she take consent and
No,
signature
not required.
of her children?
Not required. Her children is not required.
Okay, sir. Thank you, sir.
Sir, one question here.
Please.
So there is an, let's say there is an unpartitioned property. The woman has made a case against her brother after her father died after 2005, right? But the property also provides rental income, right? So in that case, she is
That is
entitled.
called as, madam, mean profit. Mean profit means whatever benefit he has swallowed by him, that can be claimed after getting partition since the day of enjoying the property without partition and without allotting any share to the sister. She can claim along with, first of all, she should prove this is the co-personary property. Secondly, I am entitled equal share along with you. Then you are also held responsible to pay mean profit from the date of father died. Since then you are enjoying the benefit arise out of the property. That is also you can claim along with the partition.
Okay, sir. Can the female also claim interest on the property over the years?
Anything you can claim. If the amount transaction was took place, she is entitled to claim equal share.
Okay, thank you, sir.
Sir, one question.
Yes.
In 2012, one partition, registered partition happened. And here it was like sisters and brothers, it was unequal partition. Where
Yes.
brother got larger portion, sister
Yes.
got little smaller portion.
Yes.
So can they challenge this registered partition, sir, now? It was
Definitely,
this previous
because
registration.
you see, that is unequal partition. You should question that document. First of all, the document you should question, because it was took place in the year brother has taken lion's share he has
Okay.
taken, and he given small share. Therefore, I need equal share. I am questioning the partition, which was now I came to know. But you must know the limitation is 3 years only. Any document, 3 years only. Within 3 years, you should claim.
If they have acted
Because
upon the property?
yourself is a party to the document. But if you
Okay.
have kept quiet for so many days, so how you are going to explain for the delay is concerned?
Okay. So 3 years
Right.
limitation is there. So not to be claimed, sir?
Definitely, sir. Just like it is a cracker, I think.
Okay.
Right.
Thank you,
Sir, it's
Sir, one
Maheshwari.
question, sir.
Please.
Yes.
Sir, if mother is getting inheritance from her father, and can she not give, if she has 2 children, one boy and one girl, can she not give to the boy and give only to the girl?
No, she cannot. Because this property was inherited as if she has taken her right from his father, her father.
Her
Therefore,
father is dead.
her father, because that is family.
Okay.
She is one of the co-partner.
Okay.
Therefore, the children are also entitled, legitimate and illegitimate children. That is the definition available in Hindu Succession Act. Legitimate or illegitimate children are also entitled equal share of the family members.
Thank you, sir.
Just now that judgment I have given, that is Shivaputrappa versus Parvatama.
Thank you,
Sir,
sir.
good evening, sir.
Yes.
There is one doubt that these days what's happening is generally the brothers put the female siblings under emotional pressure and then ask them to give in writing that relinquishing all their rights on the property, ancestral property.
Yes.
So what they do under some kind of pressure, they just give it to the brothers.
Yes.
Will that be acceptable in court if they contest it again?
Sir, definitely it is. You see, one thing, relinquishment, whether it is voluntarily or undue influence, you have to prove.
Okay.
Because it is burden lies on you, heavy burden. Because
Sir, okay.
He has got, however, he has got the property by getting relinquished in the partition. Now you see, relinquished it independently, if it is executed, it may be questioned only on the ground that he has called me and execute the document, but I do not know what document he got it executed. So
Yes, sir.
likewise, you have to claim if separate document got by him by way of releasing deed.
Okay, thank you,
Sir,
sir. Thank you.
I have
Ancestral
one scenario.
property, is there a limitation period for the
No limitation at all.
Okay.
For partition is concerned, female member, any day she can claim.
Okay, sir. Thank you.
Sir, if a female member wants to sell off the partition, after partition, the portion of her property, and the male family members do not want to sell it off, so is there any
They cannot restriction because it is her family property, not his father property.
if it is a
He is
joint
not
house
a
wherein
co-partner to her. She is alive. She is alive. She is
if
alive.
at
She
all
got the
family,
property from her brother. Therefore, children cannot claim. If she died, definitely their right is accrued.
okay.
Sir, can I ask you a question, sir?
Yes, sir.
So, in case of a divorce, all right, and they get into a settlement, the children of a mother are minor children, and the wife says, "You give me in writing, give me in writing, saying that you'll not claim for the partition in future." Is that agreement valid, sir?
No, sir. One thing is just to ascertain from that document if it is provided for maintenance for her and children, again it is joint family property. Children also entitled equal share along with mother against immovable property.
Yeah, sir, in this case, the lady doesn't want to give the children anything.
No,
and she
they can
wants to
claim
finish it off.
because the
They can
wordings how they have used in the settlement before
Yes,
the
sir.
Lok Adalat or before any other court. By filing
Okay.
compromise petition, just you
Yes, sir.
wordings because they are minor, they are in her custody. Now their right cannot be infringed. They are entitled immediately within 21 years. From 18 they are measure. Within 21 years they can question that document. We have not allotted for partition.
Okay.
Divorce
I got
cannot
it.
be affected on the children.
All right. So even if the husband signs it.
Yes, sir. Because he wants to keep the children in her custody, but he don't want to confirm their right. Therefore, the children are also entitled because mother maybe he got divorce, but cannot
Correct.
children.
Okay, I got it.
All right.
Thank you, sir.
Welcome. Sir.
Sir, one question.
Yes, sir.
Yeah, there is a family with two children.
Yes.
A boy and a girl. And suppose in the year 2010, the girl got married, and the father paid some dowry kind of thing like 50 sovereigns or 10 lakh rupees. They sold their house in which they were staying. Okay. And after 15 years, they did start some business, and it was doing good. And right now, they have some money. And the father passed away. And right now, their asset is valued around 5 CR. Will the girl be eligible for that share?
No, sir, because once she has executed the document.
Which document?
Executed the document in respect of partition.
No partition document was not there.
Then she is entitled. That is the document 2012-2004. Prior to that, if it is done, she cannot. Afterwards, now from 2010, 2110, 12-2004, she is entitled.
No, her marriage was in 2010.
Sir, marriage you need not consider. She is one
No,
of the
no. She,
member of the,
her father's whole thing was given up for marriage.
because her father is, whether it is a self-acquired property or private property, just you
Yeah,
have
it
to
was a
ask.
self-acquired property of her father that
Then
was spent for her
self-acquired property
marriage.
he can dispose it of by any
Dispose it
means.
off, and he spent it for her marriage alone. And
No,
later they were.
marriage question does not arise, sir. Marriage, 2 rupees stamp paper is sufficient. You are spending more than crores, sir.
Yeah, okay. Let us say 1
That
crore.
is the
And
point
later
of
on,
law. Marriage is not going to consider while effecting the division.
okay, okay. So after which, whatever he acquires, that's
Yes.
that is his daughter is eligible for that share also.
Yes, yes.
Okay. If
So,
it is 100
sir, that
CR
means
also.
then if a father or brother spend for marriage, they should not say that we have spent a lot of money and you are not eligible to give a share.
That was decided, sir, in Vyamama's case. One Honorable Supreme Court already decided the marriage, providing all the ornaments, everything they are making, all these property worth about 5 crores we have given to her. Therefore, she is not entitled to equal share from this property. It was decided. Those cannot be bring into the motion. Only today's property she is entitled should give to her.
What has given is given.
Given is given. It is your duty. It has been given. That's all. That is
Sir, I
duty
have one
means.
question.
Yes, sir.
Sir, now before 2005, the only brothers got partition. Sir, the father died, so without a will. So only brothers got it partitioned without sister signature.
When it was, sir?
In 1999 or 2000. Can sister come and ask now, sir, that partition, because they are also very well known, but simply after this amendment, they are.
Whether she has signed or not, sir, that document.
No, I think
then
no,
she
sir.
can. She can. Because father effected the partition even prior. Without her presence, without her name is shown in the partition deed, that is irregular partition.
No, sir, but in that Vinita Sharma versus Rakesh.
Vinita Sharma versus case, no doubt. If partition was took place in her presence. That is
but
also
they have
word
clearly
has
mentioned,
been,
sir, in previous years and all, only there was values for oral partition, so no need of
oral
signing like
partition
that.
automatically lapse, sir. Unregistered partition is also cannot be taken into consideration. That
No,
is
in
decided
register office only they have registered, and their side, that sister side's elders,
sir,
they have also
whether
put a witness.
sister's name has been mentioned, just you note down in that document. Sister name has mentioned, saying that she has already taken some of the movable and in lieu of movable, immovable property. Therefore,
So
that
there
can
is
be
no
mentioned.
time limit only, sir, for this.
3 years only, sir. Any registered document, 3 years.
No, they have not signed. No, that partition. They know that partition have took
So
place,
therefore,
but they have
today
not
I
signed.
have just you get certified copy and file it. I came to know only after getting certified copy where our properties are available.
Okay, sir. That's all. Thanks, sir.
Right. That is the, sir, date of knowledge. Limitation means date of knowledge. 3 years they have restricted. But when you came to know?
No, sir. For example, that property will be in prime location. Every day they
Sir,
should walk in
whatever
front of that only.
you need not worry about prime location. By birth itself, right has been given to her. But it is a self-acquired property of the father. Father has that property has been thrown into common stock.
Sir, for example, two sisters will be there.
Yes.
In that
Then
one
common
sister,
stock,
they.
just you.
Yes, sir.
Please note down how the
Yes, sir.
common stock. Even though my self-acquired property, I want to put into common stock. I want to partition among the family members. That means it is a joint family property.
So in that only, sir, in two member sisters will be there. In that one sister, she will orally tell. She in return only she will tell. No, my father, only his intention was to give it to only male members. So he informed all our sisters.
You must make her as a party, as a third respondent. But all the parties should be there. Who are parties born on the co-partners? All the co-partners should be parties. You put her opposite side. Whether she going to claim or not, it is immaterial.
Okay, sir. Thank you, sir. That's all.
Sir, just one question. If you're
Yes,
not completely aware of the ancestral property that, let's say, the grandfather held, and you do not know what the extent is of it, is there, in your experience, any way to kind of find that out?
Yes, ancestral property, those, one example I want to provide you. Ancestral property's name is incorporated in revenue records, stating that how he has got from father, grandfather, and great grandfather. Their names are available, and in revenue records, that is automatically it will come without any document except revenue entry. It can be ancestral, you can prove.
Okay, got it, sir. Yeah, thank you.
Sir, one question. You mentioned that the right is on both immovable and movable property.
Yes.
Let's say there are fixed deposits and gold
Yes,
ornaments.
everything, whatever property fixed in the amount, everything, that is also one of the property, movable property.
How can the female claim in that case, sir, if she doesn't know
You
which
should, because you should get information, madam, and just B schedule property you must show. That is, A schedule property is immovable property, B schedule movable property, shares, in debentures and deposits wherever he has made. Even though you do not know, but tomorrow you may ascertain. But in pleading you should mention, at liberty, I got liberty. The plaintiff is having liberty to other properties also can include, or any information has got by him, got by her or him, entitled to amend the prayer. Or otherwise, you can, those properties, if you have lost in the preliminary decree, when you are getting sale, you can file in final decree also that property to be added.
Can the female request the court to push the brothers to show the records or the bank accounts of the father?
Yes, you can file one application calling them to produce all those documents pertaining to immobile or deposits.
Okay, thank you, sir.
Welcome.
Sir, one quick example, sir. One question, sir. Sir, totally there are 3 sisters and 2 brothers. All the 3 sisters died, and both the two brothers are there without informing anyone. They have sold all the 5 crores property, and they have taken 50-50 share. Can the children of the 3 sisters claim the property, sir?
Yes, sir. Just now, writ petition from Dharwad bench, which was decided, sir, on the same issue.
Okay, and so
That
in case
sale deed, you should question now itself. You should question, because you do not know. The properties might have available with them. Your presumption always. That presumption should be bring by way of, I came to know now recently, this property is available like this.
Okay. Fine. And one more scenario, sir. In case there are one brother and one sister, father has not made any will. Now, as a legal hire, what he'll do is son will sell the property to me. Now, me being a buyer, will I face any legal issues on the property in case if I buy it?
Sir, when it is after death of father, automatically it will come as a inheritance property.
Yes, sir. Now sister will come and claim the property. Actually, what
now, sister, no, not only. His children are also entitled. The brother's son, he is also one of the co-partners, sir.
Yes, sir.
If any children are born with him, they are also eligible. They can question the sale deed executed by the brother in favor of daughter.
Okay, sir. Thank you, sir.
Right.
Sir, Jai Hind. Sir, one question that is entirely from the north, because I belong to Bihar. Nowadays, that survey is going on, land survey of all Bihar, full Bihar.
Yes.
So that people, they are started, they have got misconceptions, sir, because the rule which is already existence, this was basically being followed in south, but it was not being followed in north, sir. So division of parental property, ancestral property.
Sir, that is survey now. I
Yes,
think
sir.
two surveys are there, sir. One is a central survey and one state survey.
Yes, sir.
Now, the state problem, this is Karnataka Land Revenue Act, that is BR Land Revenue Act. BLR Act is available. In the survey
sir.
system, they have to follow under those sections. Therefore, if any violation made, you are having appeal to the higher authorities. Appeal means now ADLR has ordered for survey. DDLR you have to go, district authorities, land record authorities. You have to file appeal. Once you have received the notice they want to serve, you first file objection, stating that already it was surveyed and my property is intact. Just like you have to show, and I am objecting to survey the property because it belongs to me. Therefore, that type of objection you should file, and even otherwise they have surveyed, then you can question that before DDLR appeal.
Thank you, sir.
Welcome.
Sir, nowadays relinquishment they're doing, no, sir? For example, 2 members females and 2 members males will be there. The 2 members females will relinquish deed to 2 males. In that, 1 male member is not married and he don't have sons.
Then automatically the second son, sir, once brother died, automatically they are legal heir, second succession.
Who
As per
no,
schedule
they
2,
have
sir,
released, no, sir, that 2
whatever may
sisters.
be, whatever the property he is having, if die without issueless, automatically all the 3 are entitled equal share.
Even though they have relinquished, again those 3 will come into.
Even though relinquished, they are standing in second schedule, sir, of Succession Act.
Okay, sir, thank
Second
you.
Succession Act, second schedule.
Sir, DDLR ಸರ್ವೆನೇ ಫೈನಲ್ ಸರ್? ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಯಾರಾದ್ರೂ ಅಥಾರಿಟಿ ಇದಾರಾ? ಸರ್, ಈಸ್ DDLR ಸರ್ವೆ ಫೈನಲ್ ಅಥವಾ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಇನ್ನು
ಇಲ್ಲ, ಅದರ ನೆಕ್ಸ್ಟ್ KAT, ಕರ್ನಾಟಕ ಅಪೆಲೇಟ್ ಟ್ರಿಬ್ಯುನಲ್, ರೆವೆನ್ಯೂ.
Okay, sir.
Then High Court. There are several litigation, hierarchy of the litigation. Is there any question?
Yes, sir. This is Manjula.
Right.
Sir, yeah, I have one doubt, sir. When did woman get the right to own property alone, sir?
Today also she can purchase.
Okay.
Purchase is concerned, no problem, madam.
Okay.
If your right wants to claim against your ancestral property or your father died, his property, you can claim now also.
Okay. Okay,
But
sir.
only restriction I told you, 2012-2004
Okay, sir.
and
Sir,
99-2005.
Sir,
Become
someone
co-personal.
asked one question here, sir. Someone asked, so he is the purchaser, it seems.
Yeah.
So, and without knowing to his sister, he sold to our purchaser.
Yes.
So, they will court order to return
Definitely,
back
sir.
or what?
Definitely, her right will be automatically, it will come.
No, sir, if that brother is having same equal valuable property in other side.
Definitely, sir. Definitely, she is entirely equal share along with her brother.
No,
When
sir,
he
his
has sold
purchaser right is provided. How, sir, is purchaser right, sir? How it is?
Purchaser bona fide, he is not a bona fide purchaser. Without ascertaining family members, he got it purchased.
Sir, no, equitable partition will come into force or not, sir? Because
definitely,
if
sir. Definitely, sir. She
because
is
brother
entitled, sir.
sold here.
Her right cannot be deprived because simply he has sold, his name is appeared after death of his father. And
sir, but
he has
court
not
will
mentioned
not. Will court order to give only at this
Definitely,
place?
sir. Definitely. Equal, sir. Then in what happened, so many cases I have dealt. In Lok Adalat, the matter going to be referred. They don't want to give the property because he has purchased already and developed. Therefore, you want to decide by way of monetary kind.
But we will have that purchaser will have
No,
an option to
definitely
give in
right.
other pair.
Definitely, sir.
No, sir, he
Definitely
can
you
give in
are
some other
having a
place. No,
right
sir,
to
same
question the
valuable,
sale.
same
Valuable,
consideration.
definitely present valuable. The court going to be decreed tomorrow. If I have filed, decree has been passed, automatically as on date, what is the value I am entitled.
So that the court will not ask to return the same property, but he can return money also, no? If,
Yes, yes, sir. Yes, sir. Always, man, sir. House property, it is always only settlement. Because house cannot be partition, no?
Sir, because in some places the property will be very much developed. After 12-15 years, they will come. I am here, her sister, his sister.
Yes,
So
just
yeah,
you
I have
are,
share.
now just you put the word, first one notice should be give, because I came to know in the notice while you are drafting, it is the basic for your case. It is nothing but foundation. You should remember that in that notice, I came to know, my clients came to know about the property has been sold without our knowledge, because I am married, I am living somewhere else. But during lifetime of father, I have also enjoyed along with my brother. These are the words you can put in the notice, issue him. And this is the cause of action for you. File a suit.
No, so that purchase at 12 years in adverse possession also will be there. No, sir, he will be
Sir,
developed. Will
I
be.
do not know, sir. I am away from this property.
So in this case, what court may say,
Definitely,
will
sir.
sister should ask
Without
brother or that
without giving particulars, family particulars, he himself sold as a absolute owner. It is definitely, it is going to be thrashed out. No problem.
Okay, sir.
Sir, in that case, what happens to the seller, sir? The seller has cheated, no? Because
Sir,
the seller.
notice, sir, seller, now he can claim. Just, till today, I am dealing one case. There are 14 acres. Out of 14 acres, 7 acres has been ordered. Another 7 acres he is having. When we had been to our land, 7 acres, half of the equal share has been divided. When we went to the purchaser's property, we have already taken possession. He has to file a case against seller, because he is having also 7.5 acres where it is available. And whatever his portion has been taken, he can claim against the other brother, other family member who sold the property by misusing, by suppressing.
Okay, okay, sir. Okay.
Right, sir. Thank you.
No, sir, by way of property only we should give, or will court allow us to give via money or some other
Sir,
place?
definitely, court won't give, sir. Court cannot. But only it is Lok Adalat, mediation, and between the parties, only compromise by way
No,
of
sir, because purchaser very much development will be done in that place. So for that
Sir,
reason.
definitely his investment is protected by law.
Okay, sir. Thank you, sir.
Sir, purchaser has to provide, or the brother has to provide, sir?
Brother has to provide, madam.
Okay, sir.
But
Thank you,
purchaser had to have to give property.
Okay, sir.
Because he is stepping in the shoes of brother.
Okay, sir.
Right. Thank you.
So one question, sir. Sir, there are totally 5 brothers and there's a 5 crores of property. The first brother is the Karta of HUF in Hindu Undivided Family, but the property, his father has made the property in his youngest 5th brother's name. So now how exactly this will be sold legally? Means can the younger brother sell the property, or all the rights are with Karta, no?
Sir, how he has acquired, that is the document I need. Because whether sale, what means he has transferred. Because it is self-acquired property of 5 brothers' father. He can testamentary by way of gift, by way of will. He can be, because he has not thrown into common stock.
Okay.
Likewise, you must see the documents.
Okay, so my question here is whether the Karta has more power here or the nominee has more power.
Karta treated, if Karta wants to sell the property, tomorrow his neck going to be hanged, because there is no bona fide purpose to sell this property, because it is valuable property he has swallowed and it cannot be sold. Therefore, you have to prove all the liabilities on you. You have to prove.
Yes, sir. Thank you.
There is no any family necessity to sell this property. Being a karta, I want to manage, I want to marry all the persons. These are not the ground for necessity. Necessity means there are strict and stringent words are available while karta wants to sell the property. Necessity shall be proved.
Yes, thank you.
Shall I close now? Is there any
Sir.
question?
No
I
question,
don't
sir.
have any, sir.
Thank you,
sir.
thank you, thank you.
Thank you, sir.
Thank you, sir.
Thanks a lot, sir.
Thank you, sir.
No, thank you. Next week,
Thank
another
you, sir.
topic. Another topic next.
Sure, sir.
Yes,
Thank
sir.
Thank you very
We
much,
are
sir.
very much interested to join again.
Right. Thank you, thank you.
Yeah. Thank you so much,
Thank you.
sir. Your explanation was most helpful for us. Thanks a
Right,
lot.
sir. Definitely, definitely. Practicing purpose, it is available for all of you. I have already practiced more than 40 to 43 years in
Oh
this
my God.
field.
Yeah.
I think my name you heard. I am president of Teachers Law College.
Yes, sir. I
Right.
studied in your college only.
Thank you, thank you.
Yes, sir. Thank you so much.